Ideas can change the world. For most of human history, people suffered in miserable poverty, mainly because no one had thought of better ways to do things. Then, suddenly, in just the last few hundred years, some new ideas made life better for billions. Things like running water, the printing press, the steam engine, electricity, now the internet. We want people to keep coming up with new ideas, but there's a problem. Why would you bother to spend years inventing something if other people could just steal your idea? They'd make the money, you might not.
Let's say a guy invents a better light bulb. His price needs to cover not just the manufacturing cost, but also the cost of inventing the thing in the first place. Now let's say a competitor starts manufacturing a competing copy. The competitor doesn't need to cover those development costs, so his version can be cheaper. The bottom line, original creations can't compete with the price of copies.
That's a video made by filmmaker Kirby Ferguson. If original creations can't compete with copies, inventors will invent fewer things. What could be done to address that unfair imbalance?
In the United States, the introduction of copyrights and patents was intended to address this imbalance. Copyrights covered media, patents covered inventions. Both aim to encourage the creation and proliferation of new ideas by providing a brief and limited period of exclusivity, a period where no one else could copy your work.
Brief? How brief? I wrote this book. How long until you can copy it? That time limit has changed over the years.
First in 1831 from 28 years to 42 years, then again in 1909 to 56 years, in 1976 to the lifetime of the author plus 50 years, and in 1998 to the lifetime of the author plus 70 years.
My lifetime plus 70 years? That seems long. And it's wrong, says David Kepsel. In fact, he says no one should be able to own an idea as property, and we should just get rid of all copyrights and patents. No, that's crazy, says Lauren Siskind, who's an intellectual property lawyer. And I assume most people agree with him. So, David, let's start with you. I mean, no copyright, no trademark? Why would I write this if you could just rip it off?
Why did Shakespeare write all those plays he did before there was copyright? Why did he profit through putting his name on plays that were actually retellings of old stories? Well, because you can make money.
Lawrence, why? You know, Shakespeare did it without copyright.
They may not have had a copyright statute at the time, but people who pirated other people's plays were dealt with harshly. Shakespeare, he would go after these people, sometimes try to shut down the theater. There was copying, and it was wrong. That's another.
But if there was no law, how could he shut the theater down?
John, you've
He'd have
so
thugs
far,
go beat him up?
You have phrased this solely in terms of utilitarianism. Why will people do something if they don't get rewarded? It's also a moral issue, John. Someone who creates something has a moral right to protect what he has created, just as a farmer has a right to land that he has mixed his labor with. This is a natural rights issue, John.
The rights that are natural are those that are founded in the nature of property being scarce. So when I hold something, it is to the exclusion of someone else. Ideas are not like that, and when we have laws that allow me to monopolize the expression of an idea, it necessarily inhibits somebody else's free expression.
All right, but what about something that's both an idea and a physical thing, like a new drug? It costs these drug companies $1 billion to get it through government. If somebody could just copy it, they wouldn't do it.
Pharmaceuticals are a special problem because there's a great deal of regulation already built up with the research and development of the drugs. You have to go through clinical trials. But we see in other fields like software, where the R&D costs are much lower and coming down all the time, that people are actually opting out of the copyright and patent system.
How do they make money?
They make money by the strength of their name and by the strength of their product. They do it like other competitive products on the marketplace do, by making a good product and selling it and competing with others as the free market is supposed to work.
Well, it's not always clear how modern life could work without copyrights and trademarks, but there is at least one area of life where government does not enforce trademarks: illegal drugs. And yet, intellectual property still exists. In this gangster movie, Denzel Washington is upset that Cuba Gooding has watered down Denzel's dope, which is called Blue Magic.
That's a brand name. Like Pepsi, that's a brand name. They know that, even if they don't know me any more than they know the chairman of General Mills. When you chop my dope down to 1, 2, 3, 4, 5%, and then you call it Blue Magic, that is trademark infringement.
What do you want, Frank? I'm going to change the name on it?
I would have to insist that you change the name.
Fine by me, Frank. I'll call it Red Magic.
So, David, is that how it's supposed to work? And he'll persuade people?
Yeah, look, if somebody wants to come along and copy Shakespeare's plays and market them as their own.
Stossel.
Yes, Stossel's Hamlet. Well, you've now got to deal with a couple of problems. One is the audience is going to know you didn't write it, you're ripping off Shakespeare, and you've lost your bad reputation. But these reputational issues work in the private market. You don't need a government to come in and enforce them.
What about music? I often try to use music on this program, but sometimes I'm told, you can't use that. We don't have the rights. Actor Nick Offerman did this parody of how the music copyright system works.
But not every opinion is rendered.
Stop the audio. Shut it down now.
Why? Who the hell are you?
I'm an intellectual property attorney, and you have stolen my client's melody.
So, Lawrence, that's what you do?
No, I do that kind of thing in court, not in someone's workshop.
To you, these laws are reasonable, clear enough for most people?
Well, like all laws, they require tailoring from time to time. Reasonable people can disagree, for example, on how long the term of a copyright should be.
The rules are confusing, and they often open people up to lawsuits. Here's one example.
In 1981, George Harrison lost a $1.5 million case for subconsciously copying the doo-wop hit He's So Fine in his ballad, My Sweet Lord.
Subconsciously copying? Are you kidding me?
You know, in that case, he admitted he had made a mistake, and he tried to settle it before it went to trial. The tune was well known. He said it was subconscious, but whether it was or wasn't, he did not have a right to use someone else's tune. The fact that he was a great creative person in his own right didn't give him the right to infringe on other people's creative products.
And how would they make money if anybody could just copy any song?
They are making money through doing what they've been doing for ages, by doing performances, by hoping that people will buy their products. And in fact, they do. You know, I live in Mexico City, and I can walk out my door, go 200 yards, and buy a pirated copy of anything I want. And yet, box office receipts in Mexico City go up every year. Why? Because the people who can afford to go to theaters, the people who can afford to buy the original products, choose to.
You know, that's all well and good if you have a famous entertainer, say a Lady Gaga or Tony Bennett. But how does an entertainer become famous in the first place? The reason people will pay money to go and see one of their performances is because intellectual property law allowed them to become famous in the first place.
David?
I don't think that's necessarily true. You see a lot of independent performers now making money through doing live gigs at smaller venues and then becoming famous there too. It's not always copyright law that enables that. Sometimes it's also making good music.
Let's assume copyright protection is a good thing. What's not a good thing is that special interest groups then lobby politicians to tilt the law in their favor. And my former employer, Disney, did that. Even after making big bucks from stories like Pinocchio that they got for free.
Stories like Snow White, Pinocchio, and Alice in Wonderland were all taken from the public domain. But when it came time for the copyright of Disney's early films to expire, they lobbied to have the term of copyright extended.
Extended from 75 years to 95 years. Snow White, their first movie, would now be free to copy if they hadn't gotten their special deal. But now they control Snow White until the year 2032. Lawrence, that's not right. And I don't know that, 70 years after my death, I should own this thing?
They don't have the right to the story for 95 years. What they have a right to is their expression of it. The story of Snow White is an ancient German myth. And anybody, you
so I can
David,
do a cartoon where she's singing and...
You can do a story of any kind you want that involves a bitter queen, a mirror, a poison apple. Just as Leonard Bernstein
Disney's not going to sue them?
No, not for those basic elements. Just as Shakespeare, to get back to Shakespeare for a minute, could not have sued Leonard Bernstein and Stephen Sondheim for coming up with West Side Story, which is the same basic story as Romeo and Juliet.
And you would argue that this is this big business cronyism scam to get it extended for so long.
Yeah, and just because they're not necessarily going to win in court, it doesn't mean they're not going to use their,
Bully
pocket
lawyers
full of
to scare
lawyers to
people.
scare people. Of course, that's exactly what happens, and that happens in the patent industry too.
Have you listened to music on the internet without paying for it? Lots of people do. This upsets musicians like Taylor Swift.
It freaks me out. I'll have a meltdown on the show.
Still, college students download music all the time. But there's a name for what they're doing. It's called
downloading songs off the internet illegally.
And sometimes the music makers take action. Boston University student Joel Tannenbaum copied 30 songs and shared them on the web. The Recording Industry Association sued him, and a jury ordered him to pay $675,000.
$22,500 for each song he downloaded.
And that's not right, says the author of Against Intellectual Property, Stefan Kinsella. Why is it not right?
The internet has given us a tool to learn, to copy. This is what humans have been doing for thousands of years. This is how society advances and how humanity grows. Copyright law basically censors free speech. It prevents people from saying what they want to say, from copying, from learning, from sharing, from remixing.
Without it, people will say and mix and produce less.
That is actually not true. Today we have piracy that's widespread, and most people don't make a dime from their works, and most people want their ideas to get out there. The danger to artists and to people who want to get their name out there is obscurity. It's not piracy. Piracy is a compliment.
So I should just be allowed to pirate movies off the internet?
Well, I think piracy is the wrong term, just like the term stealing is the wrong term. When you copy information, you're not taking anything from anyone. You're copying their ideas. They still have them. Piracy is what people used to do when they would raid ships and take things.
That's a good point. And the movie industry complains about digital piracy all the time.
The Wolf gets ripped off. The Wolf of Wall Street was downloaded illegally more than any other movie in 2014. Other films making the list include Frozen, RoboCop, Gravity, and The Hobbit.
Piracy, that's where Hollywood has a really big problem, and they see eye to eye with so many conservatives. Conservatives, respect private property.
You don't respect private property. It's true, it's not being stolen, but being copied.
Well, actually, I believe in private property as a libertarian more strongly than even most conservatives. And that is actually why I think patent law and copyrights are a bad idea. In fact,
that's confusing.
Patents expire after 17 years, roughly. Copyrights expire after a long time later, as you noted already. Property rights don't expire, so it's clear that patents and copyrights are not property rights.
Let's make this personal. I'm, frankly, sometimes happy when I see that my show is all over the internet, because my goal is to get the ideas out. But it's a conflict, because I also know that why would Fox pay me to do the show if they didn't own it and get to make money from it? You who steal this show by watching it in places like YouTube may not think about the costs that go into making the show happen. It's not just my salary. I have 7 producers who do research, book the guests, have editors who cut the video. There's a makeup person, hairstylist, the studio stage manager, the director, cost of the car service that picks up the guests, like you, Stefan. How would it happen if they couldn't own the show, protect it?
Well, you certainly should have the right to have, it's moral for people to give attribution credit, right? If a YouTube video is taken, there's nothing wrong with saying, hey, it's wrong for you to not tell where it came from. Copying is a different matter altogether. When you put information out there, you should be complimented by the fact that people are copying your show. It shows that you're popular. It shows they want to hear your ideas. The more copies that are made, the more popular you are. Movie studios make money from selling tickets. Now they can make money from selling DVDs. They can sell money from rentals.
On YouTube, it has its own channel. They put up this warning video.
Everybody's really been looking forward to the new video from Lumpy and the Lumpettes. Russell's a huge fan.
But YouTube warns him.
Hey, Russell! You didn't create that video. You just copied someone else's content. You can be sued and found liable for monetary damages. If YouTube finds you're a repeat offender, you'll get banned for life.
So, Sounds like you get punished if people complain that you're stealing stuff.
You will, and it's even getting worse. One of the dangers of copyright, John, is that it's used by the state to regulate the internet. In fact, the SOPA legislation was defeated a couple of years ago, which would have tried to stop piracy by imposing all kinds of surveillance on the internet. And internet service providers recently have agreed, under government pressure, to adopt this sort of 6 strikes and you're out rule, which is like a private, out-of-the-court system with no due process, which could get you banned from the internet for life.
Not from the internet. It
Yes.
gets you banned from YouTube.
No, from the internet.
But has it ever happened?
Not yet, but these rules are pretty new. It's a danger.
So you're a patent lawyer. So
I am a patent attorney.
You're basically trying to argue yourself out of a job.
Right, just like an oncologist is trying to cure cancer and put himself out of a job, or an attorney who works for the ACLU or defends people against the hideous drug war is hoping to end the drug war, and he wouldn't, maybe he'd have to find honest work then.